Do today is talk about these new developments with China data privacy law. My name's Scott Warren. I'm an attorney with Squire Patton Boggs in the Tokyo office and as well as the Shanghai office, working with Lindsay Zhu, who's joining us from our Shanghai office. I think you'll find this interesting because, at least in my mind, there has not been any greater change to data privacy laws in the Asia Pacific region. At least in terms of its imprint on companies that need to comply with the obligations of this. And it's an interpretation of or a regulation that sets forth what it is you will need to do in order to move most data out of China, particularly personal information data. So we're going to go through the metrics of this. It's, as I said, new in that it was just passed on February 24th of this year. Implementation is coming in June, although there may be a 6-month window, additional window for companies to comply. So that's one of the reasons why we really wanted to take your time up today to talk about some of the differences in the new law and what you need to do to comply. So I'm a former litigator, so I learned that when you're in front of a jury, you want to first tell them the 3 things, maybe 4 things if you're lucky, that you're going to try to tell them throughout the trial, and tell them what you want to take away. And then at the end, you want to kind of remind them of those things. So today we want to clarify what are the obligations that are imposed under the standard contract that has to be entered into for most of the personal information exports, as well as the implementing measures that describe exactly what you need to do. We want to talk about what is the timing for compliance, how long you have to do that, and then to provide a framework. We're one of the members of our APAC team couldn't make us today, but it's really helpful. He's Nick Chan, based in Hong Kong. He's actually a member of the People's Congress and recently voted on some new changes that apply. Indeed, there's going to be a China National Data Bureau established. And it's unclear exactly what its role is going to be going forward, how much it will perhaps participate in any of the things we're talking about today. At this point, we believe that it'll become more of a thought center for how to handle data, and perhaps not the regulatory body that the Cybersecurity Administration of China is, but we're still waiting for some clarity on that. Luckily, we have Nick on board that will keep us right up to date on what's going on with that. So without further ado, I kind of want to set the stage for what's the overall set of laws that you're looking at in China. We have the cybersecurity law, which was passed in 2017, and it does have some elements that talk about personal data in general, but the most important parts of it deal with critical information infrastructure, what I think we call in the West critical infrastructure. And those are things that, anybody would think of as being part of the critical infrastructure. And Lindsay's going to go through a little better definition of what applies in that category. There was a data security law, which expands that into important data and talks about data protection or critical data protection, that was passed in September of 21. And then the personal information protection law was passed in November of 21. And, that is basically the overall handling mechanism for standard personal information and what you need to do in order to collect, process, and handle that data. So those are the 3 huge umbrella parts of the law. And then really we look at the second level implementation measures. These are things that help identify what are those things that are still yet unspecified under the PIPL and what you need to do to handle it. And one of those things is what we're going to talk heavily about today, which is the data export laws related to standard, if you will, personal information. But there's also a number of other ones, the network security review and what you need to do in those settings. What do you need to do for critical information infrastructure specifically? But it's really important for our clients to know that there's also a lot of industry laws that may apply. And so, for example, in the auto industry, there's just a number of specific carve-out laws that say, hey, you have autonomous vehicles, you're collecting data here, or here's some basic things that happen with auto industry. And then, of course, finance, medical, and a number of other areas are looked at in greater detail in those carve-out laws. There's a third level of laws, which are the national security guidelines, and those are the things that help kind of give specification of best practices that should be followed and may be helpful in identifying what type of security measures you have. So with this, I'm going to turn it over to Lindsay to talk about kind of this, and I think the way I like to think of it is you got a huge circle of law that's called, of data that's called personal information, and then we're going to carve out some of these in this slide that's going to talk about critical infrastructure and large volume. And then we'll spend the rest of the time today talking about the rest of personal information data and how you get it out. So turn it over to you, Lindsay.
Thank you, Scott. As the PIPL, which is the Personal Information Protection Law, is currently implemented, there are essentially two effective ways to transfer personal data outside of China. You either going through a mandatory government assessment or rely on signing the standard contract, which we will talk about in the rest of our presentation. But I want to first talk about, what data transfer will be subject to mandatory government assessment, because basically everything that's not subject to mandatory government assessment can rely on signing the standard contract. So the data exports subject to government assessment include if the data controller is a critical information infrastructure operator. That basically means an operator of a network or IP system that is a critical information infrastructure, which typically includes critical industries such as telecom, utilities, natural resource, financial system, public service, national defense. The CIO is actually identified by the government authority, so it's not a self-assessment. You'll get a identification from the government. Most foreign companies or multinational companies are likely not a CIO, but it's possible that your customer could be a CIO that might be subject to that law. Might be subject to the government assessment requirement. In addition to CIO, if there are large volume of personal data involved, the data export may also subject to government assessment, and this includes three thresholds. First, if the data controller process over 1 million individuals' personal data. It's not that you export 1 million, it's if a controller process or possess 1 million individuals' personal data. Second, if a controller has exported over 100,000 individuals' data since January 1st of the last year. Third, if a controller exported over 10,000 individual sensitive data since January 1st of the last year. So if a controller falls into any of these categories, then the data export should go through a mandatory government assessment. I just want to note that as Scott just mentioned, there are also specific laws relating to like automobile data, financial data, medical data that could also be personal data. Those data will be made subject to other special or industrial regulation that usually have stricter localization requirement. Next, please. So this slide shows a diagram of, the process of determining whether you can use whether you should go through a government assessment or standard contract. If a controller falls into any of the categories we talked about in the last slides, then what you should do is you need to store data first in China and transfer outside China only after passing the government assessment. If the answer of the assessment is no, then the data controllers can take the actions that are listed in the right side of the box and rely on signing a standard contract to export the data. I'll not go into details of every requirement in the right box, but I want to go through quickly. First of all, I want to point out that for exporting personal data outside of China, a controller needs to get specific consent from the data subject. So this means it cannot be blended into a privacy policy. It needs to be a separate consent specifically relating to data export, unless the consent is exempted from the situations that provided under the PIPL, which include the necessity for performance of contract, necessity for necessary for human resource management, perform legal duties, or for public interest. For whom that are familiar with the EU GDPR, I want to specifically point out that a major difference between the PIPL and GDPR is that there is no legitimate interest as a processing ground under the PIPL. A lot of the processing under GDPR can be exempted from obtaining a consent based on legitimate interest, but it's not the case under the PIPL. So there are more cases under the PIPL where you need to get separate consent. The second requirement is that a data controller should provide proper notification to the data subject for data export. This applies to, if either you get a consent or if you're exempted from consent, you still need to get notification. And the notification should be sufficiently provide information about the recipient, about the purpose, about the processing method, and retention period. And the data subject should also be informed that it is a third-party beneficiary under the standard contract, which we will talk about later. The data controller should also conduct a personal information impact assessment, which we'll go into detail in the later slides. A standard contract should be signed between the controller and recipient. So this is the main topic of this our presentation, which we will talk about in detail in the later presentation. And both the personal information impact assessment report and the signed standard contract should be filed with the government. Now, I want to just mention very briefly a third mechanism that is provided under the PIPL for data export, which is to obtain so-called personal information protection certification from a qualified third-party agency. But as of today, the government, although the government has released some measures relating to certification, it seems that at this moment, only a semi-government organization is authorized to issue such certification. So it is our expectation that until more third party, especially private companies or private organizations, are given qualification to issue such certification, this process or this mechanism will not be attractive to most companies. Scott, over to you.
Great. So just real quick, I probably should have done this at the beginning. Housekeeping, we are recording this. There's been several questions in the Q&A about whether or not you'll be able to get a copy of the slides, and absolutely. Unfortunately, I can't respond to the Q&A for some reason, but I will do that verbally. And so that's kind of the housekeeping side of it. So I think this is the concept that is sometimes difficult when I've talked with other clients on this to understand, because it gets tripped up on when do I have to comply into what. So like I said earlier, I think of the lake of personal information in a circle. I think that what the last slide talked about before this is when it's critical infrastructure or information infrastructure data, or it's large volume data, including, the 1 million to 100,000 to 10,000 of sensitive, then it's kind of in this little part of the circle, because a lot of our clients may not have thresholds above that or deal with critical infrastructure. The rest of this circle is what we're talking about. And in order, that's kind of this on the screen, the left side, the right side, no, take the following actions. You're going to need to do, and we'll talk about all these things in much greater detail, these steps in order to be able to comply. And there's kind of a limited amount of time to be able to do that. So I'm going to talk about what the standard contract obligations are. And under the Chinese law, it is referred to as standard contract. We'll probably also refer to it as the PRC SCCs as a nod in our heads to the EU SCCs. They form basically the same purpose. It's a standalone contract that is required to be entered into the exporting party that's in China to the recipient party outside. And it doesn't matter if it's a third party versus an affiliate. The obligations apply to anybody who's going to receive this data outside. And it's a standard template alone that needs to be executed, that we now have clarity exactly what it says. It has details of the processing. So this is second bullet point is much like GDPR in terms of volume of the transfers and all the rest of the details that you need to specify of what you're transferring. But what's really important about this set of laws is that there isn't a distinction under the Chinese law, at least under these contract clauses, between a controller to controller versus a controller to processor, or one of the other situations that you see in Europe. There is one contract that applies. And so what that means ultimately is that if there is a data breach, the data recipient abroad is obligated to notify not only the government and the data and the data exporter, but also oftentimes the individual. And also then the exporter outside, the data recipient outside China is subject to data access requests in response to those. The data recipient needs to keep a record of what they've been doing, not only for 3 years under the agreement. They need to adhere to requests from the Chinese investigators or authorities that are asking for information related to that data, even if it's sitting abroad. It's clear that data subjects are third-party beneficiaries, and that they have the right to claim their rights under Chinese law and under a Chinese jurisdiction. And then there's also joint liability between the data exporter and the recipient. The final part is if there's a dispute between the exporter and the data recipient abroad, those are to be resolved by negotiation at first. Failing that, it's to go to either Chinese court or arbitration. There are several arbitrating courts in China listed, but it also has a carve out at the end that says it can be by arbitration in any New York Convention location, of course, under the rules of Chinese law. And then I'm just going to compare and contrast really quickly the EU SCCs versus the PRC standard contract. it's really important to note that a data transfer is considered not only the ability, the actual movement of that data to a server outside of China, but having simple access to that data from outside of China into the servers located in China is considered a data transfer. So much like GDPR, that's the same. They also make, it's clear that this is to intergroup transfers as well as third parties. And we've talked about the fact that there's only one transfer mechanism. There's not these 4 different agreements that you have in China, depending on whether it's controller to joint controller, joint controller to processor, et cetera. Like the GDPR SCCs, there is not a way to alter any of the terms of the essential terms of the contract. There's a way that you can add some things that don't alter the essential terms at the end. And we've talked about the details of the transfer need to be provided. SCCs in the EU have a number of optional clauses which are kind of designated as appropriate. So far, none of those exist for the China standard contract. Yeah, I think we've covered all that. The last comparison I wanted to do just for SCCs and the PRC, just to make sure we're really clear on it. The duty to require notification of breaches is unique, especially in the controller to processor type of European contract. It's not required. The processor outside is only required to notify the controller within the country. So that's unique. Again, the duty of specifically who you need to notify of that includes the government in all cases. And then in most cases, unless you can show there's no substantial impact of harm to the data subjects, then you'll have to notify them as well. So one other thing that's really important is onward transfers are also very, very closely held. If you're going to transfer from the data from China to, let's say, a third party in the United States, and they happen to have resources in India that help and may be able to review the data, the standard contract with China requires you to specify all of those different onward transfers. Make sure you have a standard contract, the China standard contract, with the other entity that's receiving it, and go through the entire process. And then it's essential to obtain consent. Lindsay has provided a couple of things ways that you might be able to avoid having to get specific consent, but it is a much, much smaller opportunity in China than you would have in Europe, where you might be able to rely on legitimate interest. And then it's important to know that the government can suspend transfers if they feel that proper activities haven't happened. So with that, I'm going to turn it back to Lindsay to talk a little bit about what are the implementing measures and how do you go through the personal information protection impact assessment.
Thank you, Scott. So the personal information protection impact assessment is very important. First of all, it's not only for data export. It also applies to processing sensitive data, or if you transfer data to any third party or engage a third party to process data. Second, it's important to understand that it's not only a formality. It's essentially a process for data controller to review the compliance of its data processing practice. Because we will need for purpose of data export, the assessment report will need to be filed to the government. So after we conduct assessment, in most cases, in our experience, the company will discover incompliance issues. So before the assessment report can be submitted to the government, the company needs to take actions to rectify the incompliance. So it is important to do it as early as possible in order to take remedial measures. Next slide. I want to talk about a few key RCAs, the key areas of review and the content of personal the impact assessment report, or the PPA, what we call it. The most important principle, the fundamental area to review is whether the data, our personal data export practice meets the so-called necessary and minimum principle. In other words, the personal data can be exported only if it's necessary and to the extent minimum. And every type of, when we do the assessment, every type of data should be reviewed, and the export of such data should be justified. For example, for employee data, it's not, we cannot just generally say, oh, employee data will be transferred for, a human resource management purpose. We need to go through each type of individual's data, basic information, ID number, marital status, because most of there are a lot of employee data that could be sensitive data. And we need to go through each data and to explain in the report why it needs to be exported or why it needs to be accessed from outside of China. For a typical issue for multinational companies is that the company tend to use one centralized HR system or IT system that consolidate all employee data maybe in one system that is with the server located outside of China. So which means essentially most of the employee data are exported outside of China. So it will be difficult to justify why all these data, all the employee data will have to be transferred offshore. For example, let's say like bank account information that is considered a sensitive data under the PIPL. But why a particular employee's bank account information for purpose of payroll payment needs to be outside of China? Because the processing only happens inside of China. So this is the difficulty we have seen with multinational companies. But on the other hand, it is almost impractical, or not cost effective, or from management perspective, it is just impossible to separate the system between the Chinese entities from the headquarters. So in those cases, we need to think about alternative and solutions to justify necessary and minimum, which could include, for example, anonymizing some of the data, or the identification some of the data, encrypt some of the data, and give the encryption keys to only limited employees. We can also implement some like access control and access control process, so that even if the data is stored offshore, only limited only like Chinese HR can access it, or only a limited person that has the necessity to know can access the information. So all that needs to be is a review and rectification and implementation process that need to be done through the impact assessment process. Another key area of review is whether the company has obtained proper consent, and whether proper notice has been given, and whether the company has adopted sufficient policies, internal control to protect personal data. As I just mentioned earlier, unless you're exempted from obtaining the consent, for data export, separate consent from each data subject is required. in most cases for like HR data, employee data, consent is usually exempted, but proper notice has to be given to the employees, and the company should adopt a employee data privacy policy to implement the whole process. And the company should also adopt like retention policies and security measures to safeguard the personal data. So all that should be covered by the impact assessment report. Another another factor that or a special factor that is required for the impact assessment report for data export is the evaluation of the data protection laws and legal frame of the data recipient jurisdiction. This is similar to the GDPR, similar to the EU SCCs requirement. This includes the review of the sufficiency and impact of the local data laws and policies of the data recipient, whether the local law would have impact on the enforcement of the standard contract of the Chinese standard contract, and whether it will impact the rights and interests of the data subjects located in China. The review or evaluation should also include a reasonable care due diligence on the compliance record and process and data handling by the recipient. For example, if the recipient has ever received any investigation notice, whether there was a data breach incident in the past that happened to the recipient. So all that needs to be documented. So the whole due diligence process needs to be documented and reflected in the impact assessment report. And after the report this is more like we start to do an assessment, we discover issues, then the company to take measures to remedy those issues, and then issue or finalize the report for filing to the government. Over to you, I think, Scott.
Great. So we've kind of set the stage. Oh, and by the way, there's some great questions coming in, and I expect we're going to have plenty of time at the end to be able to answer those. But let's go through the content we have, and then maybe some of these questions will be answered, and be happy to answer those at the end. So we've talked about that this is going to probably apply to most of the data that you would have that's personal information within China, and your desire to export it, the need to have a standard contract in place, and the need to do what we're calling the PIPIA, the Personal Information Protection Impact Assessment. We love acronyms. So that kind of, those are the two things we've covered so far. The third step is that these two documents need to be filed with the government authority. And the timing is that it needs to be filed within 10 days of the actual effectiveness of the standard contract. And that no export should be occurring, of course, before you have the standard contract in place, the Personal Information Impact Protection Assessment, as well as, basically the filing done. In terms of whether we, the review discretion in terms of the government, it's our current view that probably there's not going to be a line-by-line review, or even probably a review at all by the filing in most cases that is provided with the government, unless it's a very high-profile transfer, or in the event that there is something that goes wrong, there's a data breach, or there's claims against the entity, in which case then those documents can be reviewed. And in terms of the timing of when you have to get this done, the law comes into effect on June 1st, and it is required for any new transfers happening after June 1st. Export activities occurring before June 1st are given a 6-month grace period. So the last day for basically having everything done is December 1st, 2023. Lindsay and I have had an interesting discussion about, let's say you have a policy where you are, exporting personal data of employees before the event, before June 1st. Are you entitled to a 6-month grace period for all of the exports after that, even if you add new employees? Maybe technically no, but the reality is I think you probably at least have a good faith argument to argue that you have until December 1st to comply. But this is the way the law is written and kind of what you need to comply with. And then it's really important to know that if there are any changes in the processing of those details, let's assume you originally collected the details to make a sale, but now you want to use them to analyze what was sold and try to reach out back to the individual to indicate you want to do some marketing on these other types of similar products or provide that data subsequently to third parties. If that's not specified in the original consent or in your consent mechanism that you use to gather the data, then you actually need to refile what is the true processing purpose of the detail of the personal information that you've exported. And if there's been any change in laws or policies for the jurisdiction overseas that may influence data subjects' rights or interests. So now you're going to have to figure out, okay, did somehow changes in the Cloud Act in the US maybe perhaps impact the accessibility of this data in some way? Or let's say you're a data recipient who hasn't had those type of Cloud Act requests from the US law enforcement, but suddenly you start getting them. There is a need to refile this PIPIA and explain the situation. And then it just basically has this broader carve out any other situations where data subjects' rights and interests may be impacted. So I think, within that framework, you may need to consider changes and frankly be broader with your overall consent mechanism or acquiring mechanism for that data in order to be sure that you can use it for subsequent purposes that you anticipate. For penalties, certainly the authorities may require you to rectify. We have seen in situations in the past where the penalties included the loss of the shutdown of transfer of information or shutdown of websites where there were found in contravention of the PIPL. Penalties may be up to 5% of the prior year's turnovers. Frankly, we haven't been able to determine whether that's global turnover or China turnover. There is a recent case involving Didi that is at least partially based in the PIPL, and as you can see, a $1.2 billion fine for them, and also executives' personal liability. And so you can see that there is some serious penalties that may be involved. At least in that case, it was 5% of China turnovers, although arguably that may be Didi's largest percentage of revenue. And then we mentioned that there can be personal liability of the responsible person. And it's also important under the PIPL to realize that a data transfer outside of the country does require you to have a data privacy officer that's within China. Now, the specifications of that are still being set, but that is the requirements under the law. So something to consider going forward. I'm going to turn it back to Lindsay to talk about the framework for compliance.
Yeah, this is really to basically to re-emphasize what we have talked about, just in terms of, first of, in terms of timing. In our experience, it could take quite a lot of time to do the PPO. As mentioned, it's not just a formality; it's really a data mapping, compliance review, and evaluation of foreign laws and recipient. So in our experience, it could take at least 2 or 3 months. Then you also need time to rectify the in-compliance issues or deficiencies that are discovered during the PPA process. After that, the PPA needs to be updated and finalized, and the standard contract need to be signed. This also take, our guess is at least a month. So the whole compliance process would take, at least around 6 months. So it is important to act as soon as possible. The other compliance difficulty is that if we are having a contract signed between non-affiliates, it is our expectation that some of the terms in the standard contract may be pushed back by the foreign recipient. Or if you are a foreign recipient, you may want to push back some of the clauses under the standard contract, because as we mentioned previously, that contract does impose quite a lot of obligations on the foreign recipient, and it requires the foreign recipient to gain substantive knowledge of the Chinese data protection law. So, the foreign recipient may not want to undertake this level of commitment. So in this case, the parties need to find solutions. One solution is, of course, to, like we mentioned, implement like data localization solution, or anonymizing control access. But another option is to consider, negotiating a side agreement for liability sharing. For example, require the Chinese data export to inform the foreign party about any change of law, any illegal requirement, and impose some indemnity clauses if there's a loss suffered. But all that need to take time to negotiate. So that may also take time. So again, the recommendation is that if a company involves in data export from China, either you're a controller, exporter, or a recipient, you need to act or start to at least just think about it as soon as possible. Scott.
Great. Well, that brings us to the Q&A, and I'm just going to start going down through some of these questions. And again, thanks for them. We've got almost 15 minutes that we can probably use to go through these. So if you've got them, please go ahead and feel free to add them to the Q&A. So the question I have here is, in the performance of legal duties, can you clarify if that can apply to an employer's duty of care for the safety of their employees? So I guess this is, Lindsay, in the concept of the various ways that you can actually collect and process information under the PIPL. There is the exception that you don't have to get direct consent, or if it's the performance of legal duties, and whether or not employer's duty of care constitutes legal duties.
Yes. For employees, most of the processing can be exempted. It can be based on performance of legal duty, and in most cases, it can be exempted from performance of employment contract of the employee, as well as necessary for human resource management based on a company policy. So for employee data, most of the processing, including data export, do not need consent. But the most important thing here is to justify necessity. So even if you don't need employees' consent, as a controller, still need to assess whether the transfer is necessary and whether the amount of transfer is minimum.
Great, thanks. The next question is, on the slide where we were discussing the thresholds of the million, 100,000, 10,000 thresholds. The question is, when determining if you meet the thresholds, is it based on how much information you process that is specifically Chinese data subjects, or is it all data subjects?
It's Chinese data subjects. It's or data subject of Chinese residents. So it's not nationality basis. It's all individuals that located in China.
Right. Good. Next question is, somebody's asking, is it possible to get a copy of the PRC standard contract? Of course, that is published, and we're happy to provide it to you. Please contact any one of us that's on the on the screen details now that you can see, and we'll be happy to provide you what that looks like. Next question is, can the standard contract include authorized users to distribute to a group? I'm not sure if I quite fully understand that. The standard contract is going to be entered into between the data exporter in China to the data recipient out of China, and it should be including, the entities that are going to handle that. So not sure exactly how that applies into authorized users. You can go ahead and add clarity to that at the end. Next question is, employers face a challenge with enforcing mandatory policies using consent, though. And I think this is really an important point, because especially when I'm working with my European colleagues, I almost think they have an allergic reaction when we start talking about employer and employee consent and whether it's possible and in that relationship. Look, most of the APAC region, a lot of countries don't even have that legitimate interest exception. And the need for consent is kind of expected and not nearly as adversely viewed in the region. And so I think we have to look at each of these situations under the eyes of the local jurisdiction and realize that consent is kind of the main ways of doing it, and then ensuring that our policies are going to have to reflect that consent is more likely going to be one of your solutions in the region than you might perhaps want to do in Europe, where you have maybe some other things like legitimate interest and some other jurisprudence that helps. Next question is, who is responsible for writing the impact assessment report, the recipient or the controller processor? If we're licensing the data at a research institution, does the institution have to write this report? And can we license the data generally for categories of research, or do we have to license it only for specific research projects and or specific research teams? I'm going to let Lindsay kind of get the last part of that, the meaty part. I'm going to take the real simple part at the front, which is, who's responsible for writing this? The data exporter is responsible for creating and conducting the personal information protection impact assessment, the PIPIA. And so that's their duty in order to do that. I think the second part of this gets a little bit interesting, because now you're starting to talk about research data, which, is scientific research, and there might be an exception for you to get some of that data out for humanitarian purposes, if you can justify that. But I'll throw it over to Lindsay if she's got any thoughts on the research part of the question.
Well, yeah, I think, what we talk about today are really personal data. So my guess is, if you need to license personal data from research institution, and when we say personal data, it means a data that can be identifiable to a specific person. I'm not sure, in what context will you need data like this? It's maybe consumer, consumer analysis. But that if that's the case, then I do think the research institution will need to do an impact assessment, and if the volume reaches the threshold we talk about, it need to go through a government assessment. If we're talking about research data that are not personal data, then it's, it depends on, as we just mentioned, whether it's subject to any of the other data localization requirement that could be could exist in other regulations. For example, whether it's national security data, it's medical data, financial data. So that's another regime of the question.
So here's a fun one. Does the personal information definition include personal information of deceased people? And I can see under the English translation of the law, it basically says it covers natural persons. And I'm not sure if there's a clarity on that, on its coverage, if natural persons are only live.
Well, I don't think it's specific mention. But I'll I'm inclined to say that it does, as long as it's identifiable. But I don't know if there's any, period, how long it will be protected.
Right. Next question we have is about major cloud vendors like Microsoft, Salesforce, AWS, and have they given any indication on how they will work with clients with Chinese personal information on data transfers? I can at least say from my side, I don't think Lindsay has a different experience. Since the law is brand new, the standard contract for China just came out in final form at the end of February. We've had a number of clients asking for that. For moving forward with that and even some negotiation. But for so far, I haven't had any contact with the big cloud vendors. And I don't know, Lindsay, have you had any?
I don't know about cloud vendor. Well, I do actually. I think for at least I know for Microsoft and Ali Cloud, they do have a
China-based servers.
it's more like a security solution. But what I do know is like software producers like SAP, they do have solutions for personal data. They can from IT perspective, they have IT solutions to, for example, anonymize personal data, control data flow, control data access. So that could be very useful in terms of IT solution.
Great. Another question, just in terms of getting a copy of these standard contracts, we'll be happy to supply it to you in the English translation or the Chinese version if you desire. I want to make sure we attend to this one. Can individuals' consent simply be taken at the point of collection from the individual? And if you can't do that, like the Chinese individual's personal data is coming indirectly to you from a third party, then you have to use the SCCs. You understand that one?
Yeah, if the data is transferred from a third party, the third party has the obligation to get consent. And as a recipient from the third party, yes, you just rely on the SCCs.
Yes, and I think the proper solution, especially for a lot of entities, is to obtain that consent at the point of collection. I mean, obviously it has the point of collection, but I'm thinking even of sales platforms. And when you're making a sale that is to someone in China and collecting information, certainly you may have the right to execute the agreement. They want to buy a pair of red shoes from somebody in the United States. They're going to give you a credit card and an address to ship them to. So that might be execution of a contract. But you later want to come back to them for direct marketing or providing that to other people that may want to target market, do some target marketing for those individuals. That at the point of purchase, I believe you'll want to implement a consent that says they understand these things. And because that needs to be a specific individual consent for the export, you may be able to specify some of the details within your privacy policy about what they're doing and meeting other things, so that point of purchase consent doesn't go too far. Maybe I accept, the clause and the information that's on our website, and then a link to that. But those are the ways I think you have to go through that. I am concerned with time. We got another couple of minutes. I just want to check and see. Lots of good questions here. If a multinational company headquartered in the U.S. subscribes to SaaS with a U.S. cloud vendor, where it's possible for personal information collected from Chinese affiliates and customers' employees be processed by the U.S. cloud vendor, does the multinational's Chinese affiliate have to directly contract with the U.S. cloud vendor now to get the China standard contractual clauses signed? And my view on this is that it's the duty of the exporter to ensure that they have the right contract with the data recipient that they are sending it to, and that should include any onward sends that happen, and the data recipient is under an obligation to ensure that the right clauses are that apply to that transaction that's going to include China data. So I don't see that the Chinese exporter is going to have to hop over the data recipient and do an agreement directly, but the recipient needs to make sure that the standard contract terms are in place. Let's see, and I think maybe one last question so we don't hold you too long. Let's see. Where can we get additional clarity on what is research data and what is personal data? And that is, if we collect information such as personal information or personal opinions, and it's associated with a specific identified person, wouldn't that be personal information? The definition, just to be clear, of personal information under the Chinese laws is very broad. It's similar to GDPR in terms of its breadth. It covers it's actually simpler. It just says anything that relates to an identified or identifiable natural person that's recorded in an electronic means. So in that sense, it is going to include opinions that you are collecting as to specific individuals. So with that, I think we're out of time to, I don't want to hold anybody too much past their bedtime, especially on the East Coast of the US. We want to thank you for attending today. If you have questions, you can again see different contact information for the team here, or contact your Squire Patton Boggs representative, whoever you work with. And I'm sure we can answer additional questions and help you work through the implementation of this. I just say in short, the reason why we wanted to very quickly get on and present to you some of the details here is because it is such a far-reaching law. So if you have personal information in China and you have any desire to get that out, you need to be speaking, preferably to us, but to somebody that can help you wade through all of these different nuances and ensure that you can be in compliance in a timely fashion. Lindsay, any final thoughts on your side?
No, I think you had a good summary.
Great. Well, thank you all for attending today. We really appreciate it. We wish you a good rest of your day. And please feel free to contact or reach out to us if we can be of any help. Thank you.